As a lawyer, I like to be able to trust what people say, and I've always tried to explain to people that the law should make sense. So if something makes sense, then it's probably true, and if it doesn't make sense, it's probably not. And it's probably not the law if it really doesn't make sense. But more and more, this is just not the case these days, and that is probably one reason that my channel has taken a little bit of a different turn in the last few months, because so many things just don't make sense. So on this channel, I will still talk about the law and where I think certain organizations are breaking the law or flat out lying to you, or to be slightly more charitable, misleading you a little bit. And for that, I'll give you one example that I've given you before about Keir Starmer saying that we've removed 30,000 people, which is not quite true. I'll come back to that in a minute. But also we have the likes of this from the BBC. Now, just to be clear, this story was from March 2023, but I'm going to compare it with recent articles to show how far we've not come and why this article is still relevant. Halifax woman jailed after stabbing and tying up victim. Now, if you can't tell, it's a biological male. It's not a woman. May identify as a trans woman, that's another matter. I'll come back to that in a minute. But this is one reason I say I always have liked to be able to say if something makes good sense, that's probably true. And if it doesn't make sense, it's probably not true. But that's not where we are right now. So I will explain a few of those things. But if you want my personal views on a lot of this, do check out my Off the Record channel. It's blowing up. I am so grateful to all of you for subscribing there. Well over 60,000, getting on for 70,000 subscribers now. Thank you all so much. Let's talk. First of all, I don't know which one to go to first. Let's go to the Keir Starmer comment first, where he says that we've removed 30,000 people from the UK. Obviously, he's talking about illegal migration. I've been vocal about this. We've had over 2,000 in 4 days over the last few days arrive in the UK. He says that you've every right to be angry about it. He's angry about it. So don't worry if you are angry about it. I'm angry about it because I see all too well what happens around the country. So I'm angry about it as well. So you have Keir Starmer's permission to be angry about it. And what I say here is he says that we've returned 30,000 people, which is not strictly true. If we go to the year to date, year to the end of March, excuse me, for enforced returns, those are people that have been forcibly removed, not just voluntarily left because their visa expired and they've been reminded and said, you need to be on your way now, and have voluntarily left the country, or have had no intervention whatsoever and have just left the country. They've been returned. Maybe they've overstayed and returned of their own accord, whatever. Doesn't matter. The enforced returns are 8,500, which admittedly is on the increase. It's 22% higher than the previous year. So credit where credit's due. And also, I'm not going to take away, some people think I just bash Keir Starmer for the sake of it. I don't. This is political to and fro. But credit where it's due for what they have done, not just Keir Starmer, but Keir Starmer and the whole team that are, as I understand it, dismantling boats, removing boats. I understand the engines are made in Germany. The rest is made somewhere else. And so they are breaking these down. They are trying to work up the chain for all this. There is a lot more they can do. They are not physically stopping enough boats. Boats are still arriving, but credit where it's due for what they are doing. But posts like this just lead you to not quite trust what they are saying about the rest. So this should be absolutely clear. If it's 8,500 enforced returns, just say that it's 8,500 enforced returns, because that's what it is. It's not 30,000 people forcibly returned. That's just not true. So enough about that. I'm not going to labour the point too much. But now to the story from the BBC. I cannot take this seriously. I'm sorry, but I really cannot take this seriously. Now, up until February, when the new policy for prisoners was to include violent offenders who are male identifying as female, this person would have been imprisoned in a female prison. Because presumably Zara Jade is now saying that they identify as female and therefore would have been put in a women's prison. So the story reads as follows. A transgender woman who stabbed her vulnerable victim before tying her to a chair and demanding cash has been jailed. Zara Jade attacked her victim at Halifax last year, left her tied up while she went to an ATM. Jade admitted to the offences of wounding with intent to do grievous bodily harm, robbery, fraud and false imprisonment at Bradford Crown Court. So no need for a trial, but was jailed for 9 years with an extended licence period of 3 years. Injuries inflicted, described as superficial, etc., but used tights to tie the victim into an electrically powered chair, set in the reclined position. So lying back in an electric chair, tied up with tights. Took a bank card, went to withdraw £300 cash, described as callous and cruel, etc. Now, Jade will... Just get your head around this sentence. Jade will serve her sentence in a male prison after rules banning some transgender women from female prisons. Here's another story from The Telegraph. I'll link these below, which, again, absolutely begs belief. Now, I'm talking about this because there's a very good reason. For one, we've had the Supreme Court ruling on sex and biology, and sex is based on biology. But also we have councils, which I'll come to in a moment, who are defying the Supreme Court ruling. They are breaking the law. In my personal opinion, they are breaking the law. And I will explain why. I mean, it's obvious, but I'll still explain why. So here we have the Telegraph here. Trans suspect can ask for female and male officers to search different halves of the body. Because we've had this whole argument as to whether a trans woman who is biologically male should be searched by a male or a female. And I think this is also a result of trans women police officers wanting to search women, i.e. biologically male officers wanting to conduct more thorough, intimate body part searches on women. So again, to be clear, that's the precise wording. What used to be called a cavity search. So a more thorough, intimate parts search to be carried out by a biological male on a female. That was the argument beforehand. But now this has been flipped around to talk about suspects, and now said in this sort of really bizarre compromise, police have said trans suspects can ask for female and male officers to search different halves of the body. And it's just utterly bizarre, but it says trans women with breasts and a penis can ask for a female police officer to search the top half of the body and a male officer to search the bottom half of the body under new guidance in Scotland. As I said at the outset, I would like things to make sense, but on any stretch, this doesn't just really make sense. But it is what it is, and we are where we are. But the reason I do this in this video is because the Supreme Court ruling was absolutely crystal clear. In my view, I mean, there's lots of discussion and guidance drafted, and there's been debates, and there's been threats of claims, there's been attempts at claims and so on about what it really means. All it really means is that biology is based on sex, and sex is immutable. And aside from disparities with sex anomalies, birth anomalies, and those kind of things, apart from those, and apart from the protection which remains for the protection of gender reassignment. So if you were to discriminate against somebody because they were reassigning their gender, directly or indirectly because of that, that's one thing. But where sex comes into play, sex is based on biology in the Equality Act. It was absolutely clear. And just to be equally clear, what that means with regard to changing rooms and toilets and facilities and things like that, if you are an employer or a public body, you must, under the regulations, provide separate facilities for men and women, and they are based and they are separated on biology, and that is how it must apply. If you are a public-facing service provider, you can choose whether or not you provide separate facilities for men and women, and if you do so, then they must be based on biology, and they must be kept separate by biology. If you choose not to do that and provide unisex spaces, then if they are not isolated by way of cubicle, then you risk discrimination claims. And if you don't provide them at all, and even if they are separated by cubicles or things of that nature, you still risk discrimination claims because you are not providing reasonable services for men and women separately. So that risk is there. So even as a public-facing service provider, if they choose not to provide separate men and women's facilities, they risk a claim for discrimination on the basis of sex in the Equality Act. So again, for clarity, employers and public bodies for their own employees and so on must provide separate men's and women's facilities, changing rooms, etc. as appropriate, and they must be kept separate. If they are a public-facing service provider, then they can choose to do so if it's a proportionate means of achieving a legitimate aim to provide separate facilities for men and women. And in many cases, if they don't, that might be a problem anyway. But if they do, they have to be kept separate. Men and women, based on biology, under the Equality Act, men and women. That's what the Supreme Court judgment meant. Now, what we have here is, in my view, my personal view, based on all the reasons I've given you, based on the judgment, I believe that this policy by Lancaster City Council is breaking the law. They go through to define transgender, transitioning, etc., legal framework, Equality Act, Gender Recognition Act, Data Protection Act, etc. But then they come down to changing facilities, toilets, and other single-sex facilities. Now, the clue with respect is in the word single-sex facilities. It's to be single-sex, men or women. But it says trans people, which again is either a biological male who identifies as female or a biological female who identifies as male. It says trans people are entitled to use single-sex facilities in accordance with their gender. Now, under the Gender Recognition Act, their gender changes to what they have identified, particularly if they have a GRC. So they are saying trans people, that is to say a biological male identifying as female or vice versa, can use the facilities accordance with their gender. And their gender would be those with a GRC, a biological male with a gender of female. So they are saying under this policy, and arguably without a GRC because they include proposing to undergo. So they say that a biological male can use the facilities matching their female gender because they identify as female. And then it says for non-binary people, this might mean using gender-neutral or accessible facilities or using a combination of different facilities. Now, just to be clear, non-binary people, with great respect, do not have a separate legal category under UK law. The Supreme Court also decided, with regard to non-binary, whether it was discriminatory not to have a third option, as in non-binary, for a passport, and decided, no, it's not a breach of those rights. You're male or you're female. And this policy for Lancaster says that non-binary people can use a combination of different facilities. I presume that means the men's or the women's, depending on whatever they feel like on that day. With respect, I don't mean this to be insulting. And then it says, however, trans people will never be required to use accessible toilets unless they wish to do so. So it is saying, this policy is unequivocally here saying that, and unless this has been withdrawn, but this is what's currently available on the website. So unless this has changed by now, but I don't think that it has, but that's just my caveat. This is currently available on their website. They are saying that a biological male can use female facilities, a biological female can use male facilities, and non-binary can just make it up and choose on a given day. And again, with respect, that's essentially what they are saying. And in my view, this is unlawful. Now, just to be fair, I will include what Lancaster said in their motion in support of local trans and intersex community in response to the Supreme Court judgment on the definition of sex in the equality law. This was a motion on notice submitted by Councillor Philip Black, seconded by councillors, etc., and says, like trans and intersex people across the country, the local community is trying to make sense of the Supreme Court judgment and understand the implications in their daily lives. And with great respect, I have to say it was absolutely crystal clear that there was no ambiguity in that. I think it was crystal clear. I believe that it is only because people don't like what it means that they are choosing to believe that it's ambiguous. But it isn't, with respect. Now, the council hasn't changed this policy, but they have had meetings and motions and so on, and say that they aim to create policy that maximises trans inclusivity at all times in workplace and services, and declares unequivocal support for the trans and intersex communities at this difficult time. which is fair enough, so long as it brings it within the bounds of the law, because as it stands, in my view, this policy is now unlawful, based on the clarification in the Supreme Court judgment. They will say, and many people say, that there's ambiguities and there's difficulties and so on, but I would respectfully suggest that all of those difficulties are just because they don't like the outcome of the Supreme Court judgment and what it really means for their policies, in that this policy now falls outside of the definition clarified by the Supreme Court. But as I say, I like things to make sense, and some of these just recently really don't. And so what I would say to you is, if you are in a position where you feel that an organization or a council or a company or whomever is not applying the Supreme Court ruling vis-a-vis men and women's facilities, then please don't stay silent about that. Send me details about it, send it to the news companies, and if necessary, seek a lawyer's assistance, because you may well be able to claim discrimination if you are, let's say, a woman and you are now subjected to biological men coming into your facilities. Now, on that note, there is a success story in that Penn University in the United States has now agreed to resolve the violations by allowing transgender swimmer Leah Thomas to compete in the women's category, and as part of a resolution now adopting definitions for male and female consistent with biological sex following Donald Trump's intervention, and enforcing male and female categories in sports. In signing the resolution, the University of Pennsylvania has agreed to restore female athletes' swimming records, titles, and similar recognitions which were misappropriated by male athletes who were allowed to compete in the female categories, issue a public statement to the university community stating that it will comply with Title IX, specifying that UPenn will not allow males to compete in female athletes programs or occupy Penn Athletics female intimate facilities, bearing in mind the stories that I've read about where the likes of Paula Scanlon were subjected 18 odd times per week to have Leah Thomas with full male genitalia undress and parade around in their changing rooms, and they were forced to change in front of Leah Thomas, again, fully biologically male, and absolutely just doesn't make any sense whatsoever. Regardless of protection of the category of gender reassignment, this just doesn't make sense. Forcing those swimmers for years on end, 18 times a week, doing professional training for swimming, being forced to change in front of a fully biological male who was standing around naked, just absolutely doesn't make sense at all. But again, the university has now agreed to right all those wrongs, restore the titles that were misappropriated, issue a prominent press statement, and rescind any guidance which violates this Title IX, and send a personal letter of apology to each female swimmer who is impacted by all of this mess. So again, I urge you, if you are in any way affected by all of this, do seek the assistance of a lawyer or indeed the press. But let me know what you think about any of this in the comment section below. And as always, I don't mean any of this video with any kind of disrespect or ill will whatsoever. But I do like things to make sense, and I think things should really make sense. And I do hope that these organisations now apply the Supreme Court ruling for the UK as it now applies. So thank you for watching, and I'll see you next time.